Got it. Great. Thank you. So I'm gonna start off with some questions that have come up from some of the earlier class conversations that people have stopped me and asked me after class. But one thing that's come up is within the sort of larger corporations. So if you're not currently with one of the larger corporations, maybe this question is back to when you were. It seems like there would be a tension between the operating units, which may be thinking about patents for one set of uses, and you could imagine a world where the IP functions would be dispersed out into the operating units. And a centralized IP group, which on some ways presumably has to serve the operating units, on the other hand, can be thinking about patents for all the other ways that we think about them as an asset class in some ways, or as a defensive tool for the overall company. And so I guess, within your experience, is there a more or less common model between centralized IP management versus distributed? And what do you think of the pros and cons of one versus the other?
Well, I'll jump in. My experience at GE is a conglomerate. As you realize that it's worldwide. They have very disparate business units, but all of the patents in GE's portfolio, and at the time, it may have been one of the world's largest. It probably still is one of the world's largest, over 30,000 or so. But they run the gamut from patents around superconductivity, high temperature superconductivity, to a washing machine and airplane engines and things like that. And the business units are primarily responsible for determining the fate of the IP that is pertaining to their business and generated within their business. However, the patents themselves are under control of this corporate IP and licensing unit. So as Oren mentioned, I mean, there very much is this tension that, and it's sort of a creative tension at times, that the business units are primarily interested in freedom to operate. They primarily are in defensive portfolios, but the corporate unit, from a corporate perspective, you'd like to take advantage of the IP assets that you have and see what you can do outside of the core business unit interests. And this is where I think the open innovation motivation stems at GE, and trying to license outside of the core business unit interests. So very often, the pure IP plays that GE is involved, or GE was involved in, would occur with the blessing of a business unit, that it's okay, we're not going to work on this particular thing. I'll give you an example. A GE Lighting, very old business, having to move from incandescent lighting to either compact fluorescence or LED lighting. At some point, kicking and screaming, the business unit was moving in that direction. But in their research lab, they had been working on both LED and organic LEDs for a long time, and they were really very good. And so, with the blessing of the GE Lighting unit, they saw that sort of their interest in lighting was further down the road, but all of this tremendous technology and organic LEDs could be leveraged in the display area. Where, as you know, you can go to Best Buy right now and you can buy a really beautiful organic LED television from LG. And some of that technology, the encapsulation technology and things like that, is partly due to GE technology.
I think from my standpoint, it's a matter of focus in the company itself. So at IBM, I'll start back there. The structure was such that, if you look at the organization itself, right, it reported to the general counsel, right, and so then there was less of an involvement between the business units and the intellectual property organization, because it was treated more or less like a legal function. When I took over the organization, we did a re-engineering study and immediately fixed that problem, which I thought was a problem because we were fairly conservative company up until that point. We then reported to the CTO of the company and became a business-minded focus and became much more aligned with the businesses. When I'm at Philips, it's very similar, but even to a larger extent. You know, I'm the Chief Intellectual Property Officer of the company. I'm on the executive committee. I report to the CEO, right? So it's recognized as an important part and element of the business. And when we do our strategic planning, I make sure that my strategic plan is completely aligned with each of the business's strategic plans. So the business plans have to align. Otherwise, you're going to run into this issue where the business wants to do this, and you're doing this as the IP organization. In a sense, you're functioning for the businesses, and you have to be aligned with them as they conduct their strategy. So it's an alignment where you make a decision between a licensing model, where you can choose to license out patents or technologies that are maybe outside of the core business, or you can choose to do with the exclusivity model, whereby you want to maintain exclusivity in the marketplace, and you choose, along with the business, to not license those because you don't want anybody else doing that technology other than yourselves, and you want to protect that space very carefully. So I think but once again, those decisions are made with the businesses, and like I said, reporting as a business, I think, was the right decision for us.
Yeah, I think that's the key thing. I think you have to have a centralized focus, even if it's distributed at some level like GE, this is my opinion. I think the important thing is if you're trying to bring money in for licensing, and the business units may worry about defensive and exclusions of competitors, but ultimately when you're bringing money in and you come with a handful of money, that's really what they like to see, because it lets them do more investment, right? It lets them do offset costs. And unless you have a person that's got that, like in the case of Brian, unless a person has that stamped on their head, it's not going to happen if it's more distributed, right? It just doesn't have the same focus. And I think it's the kiss of death to have it report to the GC, the General Counsel. And I don't know what it is, but my and maybe you guys have had different, but for some reason, general legal and IP attorneys, they just don't understand each other, you know? And if you have it reporting to the GC, it seems like the GC thinks that IP is just, you know, that's not important. And I don't know why that is. But those are kind of other points. But I would say centralized business unit with having distributed function is okay. In the case of Nokia, I'll use that as an example. Our the HERE mapping division kind of held their own patents, so to speak, control of their patents, because that was a very core and key area. But we worked with them, I personally worked with them to try to go out and see if we could license it elsewhere. So I think you can have both, and the centralized group always has much more experience in terms of the negotiations, the intellectual property aspects, all of that. That's hopefully changing now with your classes that you're offering, because there's a broader set of people that now that understand intellectual property issues. But I think that's important.
Yeah, actually, so Laura, I'll ask you. The three panels you've heard from already come from organizations where IP out licensing was a significant source of revenue generation. So I know GE licensing is a famous pedigree and has done very well for itself. IBM, Nokia, all are very focused on trying to generate revenue from their patents. Google, on the other hand, as far as I know, has not actively tried to monetize their in-house patent portfolios, although I could be wrong. So does first of all, am I right? And secondly, if so, does that influence the decision about where the IP portfolio sits?
Well, I think that's in flux. So we do have out licensing. There's a recent contact lens technology where we developed internally, and then there's a license. And what's unique there is there's the transfer of the technology too. So it's licensing of patents, but also technology. And I think you'll see more of that as we develop things like this innovative contact lens technology. So I think when I say it's in flux, it's simply because for a long time, patents was a very small group, and we've grown a lot in recent time just because of what's going on in the ecosystem, and now we're centralized, we're within legal, and we still try to make decisions that sort of cut across all of the different product areas and their needs, which are starting to differ. So I think we're at the point where we're we're before what all the folks on the panel are talking about, which is a internal structure where you have this in place for a long time and you sort of know how to react to it. I think we're still building to that as we have more out licensing of technology.
Got it.
I think one of the salient points is the difference. You know, you mentioned out licensing being a large part of it. I think I've always preached that the value of intellectual property is not through the licensing money that's brought in, it's through the value of the portfolio and protecting the businesses that you have. And so what we've done at Philips, which I have not seen at any other company, is a fairly sophisticated financial model that measures the benefits, the non-cash benefits of the or the non-business sector benefits of intellectual property. So what it does is it takes into elements such as, okay, you're getting additional exclusivity in the market, you can convert that to a dollar amount. You're getting premium profits that you're able to put on top of your products because you're not having to pay these license fees that others have to pay because you've got a patent position that protects you. We convert all that into a financial model, and I go out every quarter to the CEOs of the different businesses and say, this quarter compared to last quarter, your sector benefits have gone up because the portfolio has protected you and the value of the profits has gone up. And so they get that, and that's an easier way to make the sale to the business leaders because they're saying, why do I have to spend all this money on patents and prosecution, the hundreds of millions of dollars? Well, this is why, because it's protecting you, and here's the dollar amount and the value for that.
And does the value that, so does that financial model come into play too when the business units and you are having these discussions about should we keep the patent and use it to keep competition out, or should we out-license it and try and make some money? I mean, how does that discussion typically go?
Well, it's more of what is the overall goal. If they want to have an exclusive position in the marketplace, then obviously you don't want to out-license that. But if it's a small position in the marketplace and you're not going to generate that much revenue, then yes, it's a cost-benefit analysis, and this tool will allow us to make that determination.
The only thing I would say, and I agree with all that, but the only thing I always worry is using patents to drive the exclusivity piece. You know, that to get the competitive edge, you can't rely on that too much. You really have to keep innovating. So there's a balance there. You know, you want to exclude, and maybe you want to get that running start for a couple of years, establish the market, but don't always rely on your patents. I mean, it's hard when you're a startup. Obviously, you have to rely on your patents to keep others out. But when you're an established company, you should really be innovating rather than sitting back and using your patents to remain competitive.
I think actually, oh, sorry.
No,
I was just going to add, that's why the out license should have the in license too. So I think to that point, I mean, you have patents, but so do they. And the goal should be a cross license that's mutually beneficial to both of you so that you can just innovate rather than worrying about the litigation down the line. That's really our goal with licensing.
I was going to say something very similar, just that I think that speaks to the benefit of having more a centralized licensing organization, so you have a view of in-licensing and out-licensing, and you can be more strategic about these decisions. And then I would also only add that I heard a sage remark from a patent attorney once who said that all of this stuff, forget it, the patents are not a wall, they're a speed bump, so take that as a grain of salt,